September 27th. How's that date look for you guys?
Looks fine for me, honey. Or honey. Oh my goodness, Your Honor. Oh, I don't.
I didn't know you cared. I didn't know you cared.
Oh, geez, oh Pete. How embarrassing.
Oh Lord. This has been a great morning so far.
Oh.
You, Mr. Boris.
That's fine with me. Same time, 8:45?
Same bat time, same bat channel. All right.
All right.
Eric Williamson.
The authorized representative for Eric Williamson is here.
Say again, sir.
The authorized representative for Eric Williamson is present.
Are you Eric Williamson?
I'm the authorized representative for him.
Okay, so are you an attorney?
No,
Okay, so the authorized representative who's speaking on behalf of Eric Williamson, what is your name for the record?
I'm the trustee for the Revocable Living Trust of Eric Williamson.
So you are Eric Williamson and you are the trustee as well as the beneficiary of the trust?
Correct.
So Mr. Williamson, I just want to know what to call you because I'm not going to say beneficiary of the trust for Eric Williamson every single time I need to address you, just for ease of talking to people. So Mr. Williamson, I have you here for LBNB Funding LLC in case 24020487. Who do we have?
Good morning, Your Honor. Cezanne Barda.
Mr. Barda, good morning.
Well, the best I could do is a coffee filter fez, but it seems to be getting the job done.
I'm gonna see.
If you have to, Your Honor, I will.
All righty. I'm going to put the two of you into a breakout room where perhaps you can discuss this matter set for a bench trial today.
I think
I might have to set. I think I might have to set this for an in-person just so I know who I'm dealing with for identification purposes. But
it's also set for a plaintiff's motion for summary disposition, Your Honor.
That is also correct. So that's why I'm going to put the two of you in the breakout room for, see if there's any resolution. So let's see. Mr. Barda, you had the opportunity to speak with Mr. Williamson. Was there any resolution in the matter?
There was not, Your Honor.
All right, I'm going to set this for an in-person bench trial. Make sure we have all the witnesses and everything you guys are going to bring.
The plaintiff's attorney here is visibly upset, and rightfully so. This is absolute nonsense. He does not want an in-person appearance out of this deal. Oh, it's good stuff.
Let's look at a date.
Your Honor, can our motion for summary disposition be heard prior to a trial date?
Yeah, I'm going to hear that right now, but I just want to pick a date first that so if it doesn't, if the motion is not granted, then I have a date already lined up.
Yeah.
Looking at the date of, let's see, July.
Oh yes, today's video is all Alyssa's fault, as is often the case. Thank you, Alyssa.
August 9th at 8:45. All right, so we'll do the trial date's going to be August 9th, and that'll be in person. Now,
Don't worry. He hears the motion for summary disposition coming up here, and it's subtle, but Slavin is fantastic. We don't get to see this offset, but the judge just calmly hammers him so good.
With regard to the motion for summary disposition, hang on one second, because let me just check this other case here. This is case 24020487GC LVNV Funding LLC versus Eric Williamson. Appearances, please.
Good morning, Your Honor. Cezanne Bardapi 65425 on behalf of the plaintiff.
All righty. And Mr. Williams, your name for the record?
Eric Williamson.
All righty. And this is the motion for summary, plaintiff's motion for summary disposition. Mr. Williamson, did you or your representative of the trustee of the trust file an answer to the motion for summary disposition?
No, I haven't.
All righty.
Of course you haven't, but it starts right there. Did you, or whatever the hell you call yourself, file a response? Of course you didn't file a response. We know what your response is. Your response is this.
Which is number one, wrong.
But you didn't file anything. We know that.
And then I'll allow you to make whatever arguments orally on the record. Counsel, this is your motion. Go ahead.
Thank you very much, Your Honor. Plaintiff's motion is based on MCR 2.116C9C10. There's no genuine issue material fact to move forward at this time. Attached to our motion, we have the chain of title documents, the bill of sale that shows that LVMV is the rightful owner. We have statements that were mailed to Mr. Williamson, payments made, which comport with the account stated theory. We also have an affidavit from our client showing the damages and what is owed. Mr. Williamson not only did not file a written response to our motion for summary disposition, but failed to file a counter affidavit, which is a must under the Michigan court rule. So at this time, plaintiff respectfully requests that our motion be granted. I'd also like to point out that in defendant's answer, he accuses the attorneys in my office to be guilty of securities fraud and perjury. And he also states that the 23rd District Court is an improper administration with not suitable court, according to Congress in the United States Republic. So at this
You know, the usual nonsense.
time, plaintiff would ask for the motion to be granted.
And Mr. Williamson, your response?
Judge, this is the improper venue for this matter. All lawsuits are supposed to be sued or dealt with in a district court.
This is the 23rd District Court of the state of Michigan, so yeah.
Original jurisdiction.
I have original jurisdiction over this matter.
Anything else?
Pursuant to all the Supreme Court cases regarding the long-arm statute of the state of Michigan, you reside in Pickwick and Taylor, is that correct?
Correct.
Right. And under the Michigan Constitution, this court has jurisdiction over all cases under the $25,000 with regard to those that are filed for civil reasons, not criminal reasons. And this is not a criminal case, it is a civil case for breach of contract. In all breach of contract cases, the jurisdiction then would fall to this court.
Objection.
Under federal and Michigan law, so.
Objection, Your Honor. I don't have a contract with LVMV or with its attorneys. For the record, the promissory note or dismiss this case because I don't have a wet ink signature with any of those people who's bringing me to court.
Right, but they have, they are the true owners of the debt that you incurred with Credit One.
They're not a party to the matter.
They purchased the debt.
Okay, if they purchase this, it's their debt. That's a charged off debt.
All right, so is there anything else you want to add, sir?
No, I'll be in court.
Which is number one, wrong.
I find that there is a reason to grant plaintiff's motion for summary disposition. for the reasons stated in their brief in support and on the record.
Court costs.
The council send that in via the portal. With regard
Yes,
to
Your Honor. Your Honor, there is a order for summary judgment on the last page of that, of the packet that you're holding.
So now with regard to the damages,
Damages are $1,404.15. And court costs are $117, which consists of a $55 filing fee, a $42 service fee, and a $20 for the motion for summary fees.
I find that the damages stated do comport with what was prayed for in the complaint and also matches what was attached as the underlying debt from Credit One Bank. I'm going to effectuate that, and both parties will receive their true copy of the mail.
Thank you, Your Honor. Have a great weekend.
You do the same. Both parties have a good weekend.
All right, good morning in the jail. Please state your name.
Emily Graves.
All right, so we're pushing the breakout room. They are timed. I'll give you about 4 minutes.
It's no problem.
My family. I was not finished with my statements. I would like to continue.
But go in front of the judge right now, ma'am.
Okay, I edited that, but it's clear to me that she was she was giving a long statement in the jail to nobody listening whatsoever. And she wasn't done. Oh, I get it. She's not all there, but this is fun.
Okay.
All right.
Nobody really gets hurt.
This is case 240-784 OM, City of Pontiac versus Emily Sue Graves, appearance to the record.
Nancy Plaster, for purposes of arraignment only on behalf of Ms. Graves, waive former reading, stand mute, ask for plea of not guilty. She is requesting court-appointed counsel. I would ask the bench warrant be set aside. And respectfully, we're asking for a lower or personal bond in this matter. She was not aware of any warrant going out in this case.
Court will enter a plea of not guilty on behalf of Ms. Graves. Ma'am, please state your name for the record.
Emily Graves.
All right, this case will be called a bench warrant. This case will be before Judge Walker for a pretrial conference on August 5th, 9 a.m. on Zoom. That's the bond, pretrial services, bail recommendation.
Thank you. The defendant was interviewed. Information was not able to be verified. She's a 26-year-old single female with no children, indicated living out of her car off and on for the past 6 months, did provide that address on DeQuinder for mailing. She reported being unemployed for 1 year. She does have a history of failing to appear. She has not been convicted of 2 or more violent charges, though she does have a violent matter out of 43rd District Court that's pending, as well as bench warrants out of 37th for 2 counts of assault and battery. She was on that matter at the time of the incident. Therefore, Michigan Statute 7656A does apply. She's not eligible for a personal recognizance bond. The alleged victim in this matter is listed as Glinda Ross Miles. Appears that they were strangers. The incident occurred at Ms. Miles' place of employment. Given that information, release under cognizance is not recommended. Would recommend conditions of pretrial supervision, no alcohol or controlled substances, no firearms or the dangerous weapons, and no contact with the alleged victim. Thank you.
All right, Ms. Plaster, you want to make an additional bond argument? Okay. What you make?
I would add nothing additional, Your Honor. We still would request a personal bond.
So this matter will set bond at 2,510%. Pretrial services supervision. She is not to consume any alcohol or drugs.
She's warming up.
No contact with Linda Faye Ross Miles, and she is not to possess any firearms, ammunition, or other dangerous weapons, not to be around individuals, those items, important areas where those items are present. So Judge Walker will see you on August 5th at 9 a.m. on Zoom, Ms. Graves. You're all set. Just stand up and walk through the door.
Judge, I would like to make a statement to you. Do you have time?
Ms. Graves, you don't make a statement at this point because you may incriminate yourself, okay? So
I
just wait till you-
will not incriminate myself. I will not. Do you
I would
want-
recommend against it, Your Honor.
All right,
I would
well,
like to
Ms.
make a
Plaster-
statement.
Ms. Plaster is representing you right now. Stand up and walk through. She says she doesn't recommend you making a statement, but
I would still like to go ahead and make my statement regardless of her advice.
all right, Ms. Graves, I don't have time to go through this. What is the statement about? Don't tell me what you're gonna say. What is it about?
The current false allegations being accused
Okay, well,
against me.
Ms. Graves, that's why you have to have an attorney, because I knew it was gonna go down. Talk to your attorney about the statement and give your attorney the evidence you have that's false,
Yes,
that this is false. So you can fight it in court, not here. So Ms. Graves, stand up and walk through that door, or I'm gonna raise your bond, because you're not listening to me. Walk through the door, you're all set. We're trying to protect you. Please walk through the door.
Zip it.
Call the jail and have them remove her from the room. Walk through the door.
Through the door.
is this session ending?
No, don't let it hit it
Because
on the
it
way out.
hasn't ended and you want me to exit.
No, the next person needs to come in.
So has this session with me ended? I have the right to ask.
You can leave, yes, you're done. The next person needs to come in.
I'm done, thank you. You know your paperwork? I was actually asking.
Well, there you have it. Just a quickie. Just a quickie. Thank you, Alyssa. The judge thankfully cut her off before she did any damage to herself there. Her attorney was doing the look on her attorney's face, and she said, I have something to say. She's like, no, you don't. Oh, you don't. She probably heard half of her ramblings while they were waiting for the case to be recalled after the intro. And she's like, no, we don't want any of this on the record. Good times. Thank y'all for coming out. So nice to have functioning internet. I will see y'all soon.